this episode, we will discuss default judgments and how to fight back. Welcome to Clear Your Debt, Claim Your Future, where we give you the tools and insight you need to defend yourself when you are faced with a credit card lawsuit and aggressive collection tactics. I am your host, Stio Gio, managing attorney and founder of Gio Law PLLC here in the heart of New York City. Before we start, let me remind you that this podcast is for informational purposes only and is not legal advice. Every case is different, and nothing here replaces speaking directly with a qualified attorney about your specific situation. Today's topic is one I've seen all too often: default judgments. If you have ever learned about a lawsuit only after your wages were garnished, or your bank account was frozen, or a lien was placed on your property, then you have experienced the consequences of a default judgment. But here's the good news: there are ways to fight back. So what is a default judgment, you may ask? It is when the court rules in favor of the plaintiff, either the original creditor or the debt buyer, simply because you did not respond to the lawsuit or appear in court. Simple as that, right? In New York, if you fail to file an answer within the required time, 20 days if you were served personally, or 30 days by alternate service, or you've skipped court appearance, then the plaintiff will request the default judgment to the court. This judgment is not simply a piece of paper. It is a legal order that allows the creditor to garnish your wages, freeze your bank accounts, or place a lien on your property. And once a default judgment has been entered, it remains enforceable for 20 years in the state of New York, with interest accruing as well. Now, how do default judgments happen? Great question. Most default judgments happen for one of three reasons. Number one, you were never served with a lawsuit. This is often due to improper service, sometimes called sewer service, where the papers were never actually delivered to you. So how would you know? Number two, you did receive the papers, but you didn't understand the deadline or the court process. The court system can be intimidating for many people, and some people freeze instead of responding. Number three, you ignored the lawsuit, assuming it would go away. Unfortunately, lawsuits do not disappear. Ignoring them makes it easier for creditors to win without proving their case. And this is equally important for debt buyers, who almost can never prove their case. As we mentioned in prior podcasts, a debt buyer must show chain of title. More often than not, they're unable to do so. So don't let them win. What are the consequences of a default judgment? Once a default judgment is entered, the creditor gains powerful collection tools. There are three collection tools in New York. The first is wage garnishment. In New York, up to 10% of your gross wages or 25% of your disposable earnings, whichever is less, can be taken directly from your paycheck. Number two, bank restraints. I see this all too often. Your bank account is frozen and the funds above a certain exempt amount can be taken. And number three, less often, property liens. A lien can be put on your home or other property that makes it difficult to sell or refinance. Interest accrues annually in New York on a judgment, and it can dramatically increase the total amount that is owed over a period of time. So how do we vacate a default judgment? Well, the most important takeaway is to understand that a default judgment is not always the end of the road. In many cases, you can file a motion to vacate, which is essentially asking the court to cancel the judgment. In New York, you typically need to show two things. Number one, a reasonable excuse for not responding or appearing. For example, you were never served, or you were out of state, or seriously ill, or had another valid reason. And number two, a meritorious defense. Attorneys like to say reasonable excuse, meritorious defense. A meritorious defense is a legitimate legal argument against the creditor's claim. For example, the statute of limitation has expired, the plaintiff lacks proof, or the amount claimed is wrong. If you're arguing improper service, then you file a motion under CPLR 5015A4 for lack of jurisdiction. If you're arguing excusable neglect, you file a motion under CPLR 5015A1. Those are the more common ones that I've seen. I've had cases where default judgments were years old and were vacated because the creditor couldn't prove they served the defendant properly. Now, why does acting quickly matter? Well, it's pretty simple. Time is critical. The sooner you act after you've discovered a default judgment, the better your chances of having it vacated by the court. Courts are more willing to vacate if you file promptly after learning about it than if you've just sat there for months or years. You gather all your evidence. Number 1, proof of your address at the time of the alleged service. Number 2, travel or hospitalization records if you were away. Number 3, copies of correspondence with the creditor or their attorney. So once the judgment is vacated, the court puts the case back to its original starting point, and it gives you, the consumer, a chance to defend the case on the merits. Now to recap, we've learned 3 things from today's episode. Number 1, default judgments happen when you do not respond or appear in court, and it gives creditors powerful tools to collect. Number 2, even if a default judgment is entered against you, you may be able to vacate it if you act quickly and you have a valid reason and a defense. Number 3, the sooner you address a default judgment, the more options you have. So in closing, if you've been hit with a default judgment in New York, please do not wait. Every day counts. Call me at 917-764-3072 for a free consultation. I will evaluate whether the judgment can be overturned, and I will fight to protect your rights. Thank you, and until next time, like and subscribe.